Welcome to the Contract Teardown Show from Law Insider, where legal experts tear down contracts from some of the most well-known companies and high-profile executives around the world.
In this episode, attorney Mathew Kerbis walks us through a confidential separation agreement. So, let's tear it down. Mathew Kerbis, welcome to the Contract Teardown Show. How are you today, sir?
So good. So happy to be here, Mike.
We are getting into some nerdiness. This is some new nerdiness because we have not talked about this subject before. We're just firing people. We're firing people left and right. I don't want to say that it's relevant in the current economy, but if you're in certain industries, hello tech, it might well be. We are doing a confidential separation agreement and general release of all claims. Let me show it to the folks at home. As I do this, Matthew, what is this document? When are we going to run into this kind of thing?
Oh, you're going to run in this kind of thing if you're an employer and you have to see somebody go. Usually it's somebody who knows something more than you want the rest of the general public to know. Or if you're one of the unfortunate people who is being let go, you're going to see maybe this too, depending on how high up in the company you are. And again, sort of what information have you been privy to while you've been working there.
You're going to get this in a cardboard box. Don't take the company's stapler. But what about you, Matthew? What brings you to documents like this?
Well, I actually represent both employees and employers. So yes, my malpractice insurance provider wants me to say I always do a conflict check, and I always do. But my whole business model is sort of built for the everyday person to be affordable. So that's why I tend to be more on the employee side with this type of thing. But I do represent some smaller employers, and on occasion have had to draft these for them.
All right, well, let's dig into this document, and we're going to start with a keyword, which is confidential. It mentions it in the title of the document, and also down in 6.1, it defines confidential separation information. What do you think about the way this document is dealing with this term confidentiality, and how the people who are having to read this document while, through tears as they walk out with their cardboard box? We've all been there. Maybe you haven't been there. I'm fairly unemployable. I've been there. What do you think about the way they're handling the word confidential?
Yeah, and at least this person in this document is walking away with $500,000, so I think they're not too unhappy. At least I wouldn't be. But all that being said, the confidential side of it, people think, oh yeah, like I had confidential information, I can't talk about that. But no, this document itself, the fact that you're signing it is also confidential, and that's something that at least when I'm representing the employees and they're getting this type of document, I have to explain that to them, former employees. Soon to be. And it's like, you can't tell your partner, you can't tell your parent, and you can't tell your infant child, really, according to the way this document is worded. You can't even discuss that this document exists. Now, that's, of course, pending any kind of, while this particular confidential separation agreement doesn't go into it, I have seen them drafted where it says that's unless, there's a lawful subpoena that you're responding to. But even then, usually that has to be cleared with in-house attorneys before you can even still disclose that. So that this document exists, the only people who should know in the entire all plane of existence in every multiverse is just you and your employer, and that's it. Do not talk about that this document exists and that you signed it.
I love the optimism. I'm skeptical, but I love the optimism. Well, let's talk about an annoyance, the company. And I'm going to preface this by telling you a story. There is a highly underrated movie called Mickey Blue Eyes with Hugh Grant being taught how to be in the mob. It is hilarious, and I love it. But there's a restaurant in the movie called The La Trattoria. The La Trattoria. Let's talk about the company.
That is a great reference. I saw that when it was in theaters when I was just
oh my
a wee
gosh.
little child.
I didn't even know they had theaters back then. But yeah, a Hugh Grant on a widescreen. I mean, you just can't go wrong.
Oh, yeah. So I rewatched it recently. It kind of holds up. It is funny, though. So yes, the redundant the. I saw this a lot when I was a litigator, where I've since moved into transactional work. I've always done transactional work, but as a litigator in like motions and pleadings, you see the plaintiff, the defendant. Well, that's incorrect. It's a proper noun. That's like saying the Mike, the Matthew, the Walmart. Of course, there is like a location, the Walmart, so it doesn't work perfectly there. It'd be like saying the Microsoft, right? Like it's not, it's extra. Does it change the meaning of the contract? No. Is it a little bit confusing? Yes. Is it technically it's wrong, and also less words in a contract is always a good thing. So if you can make it less wordy and a shorter contract, I think that's a good thing. And so take out the before company. They don't do that with employee. So this contract is drafted correctly when it comes to the proper use of a capital E employee. But if a term is defined in the beginning of a contract as instead of XYZ company, we're calling it company in quotes, or Mathew, we're calling employee, whatever that defined term is, you should not be putting a the in front of it. Get rid of the.
That's right. And Californians, I want you to pay special attention because you don't ride the 10. There's only one 10. You ride I-10. You ride 10. You don't have, it's, there's a whole SNL bit about this. The Trattoria is a wonderful restaurant. Well, let's jump to section 2.1. We're talking about severance payments. You had mentioned in preparation that there are a couple of sections in this document that look like they are play-withable, negotiable. Let's talk about the first one, severance payment 2.1. What do you think about the way this document handles that?
Yeah, and it's a good point, the whole negotiability thing, and especially since I tend to be representing employees more than I represent employers. A lot of employees that I've represented in this type of situation think, I have to sign it, right? Like I don't have a choice. Like this is what the company's offering, or especially if they've seen one of these documents before, the nature of their employment, they think, oh, the companies, they don't negotiate this. Like you can't negotiate this. This is the amount they give you. Maybe it's company policy. It's like your severance payment is going to be however many years you worked here, and that's the amount of weeks pay that we give you, that kind of a thing. And while that might be company policy, and while that might be what they've done in every severance agreement that maybe you've seen doled out, if that was the nature of your work, if you were in human resources or legal or something at the company, everything's always negotiable. Always negotiable, and especially that number. And depending on what type of leverage you may have against the company, what kind of specialized knowledge or sort of weird things some of the executives were doing that you know about that they shouldn't be doing, you might be able to get a higher number. So you're always going to want to negotiate a higher number on the employee side, and of course on the employer side, you want them to think, oh no, this is what we do for everyone. We try to treat everybody equally with these separation agreements. This is our company policy. But I'd always encourage the employees to see if there's a reason they can negotiate a higher number in that regard.
Speaking of, I saw a tweet recently where someone had been fired from a restaurant, and then their former manager, texted them and said, hey, did you do inventory? We're trying to find out how much butter there is. And the guy was like, bro, seriously, you let me go. When you get rid of somebody, especially at the high level, presumably that this person is, they know where bodies are buried, and the company, to continue operating, will need to know about the buried bodies. So let's jump to 6.3 and continuing obligations. What do you think about that section and the obligations that it puts on the person who's leaving and on the company?
Yeah, specifically here, you'll see things also like like non-competes sometimes are in this type of a thing. Now, in this particular contract that the audience is looking at, there's a non-solicitation in there. So you can't take any employees with us for the term of 1 year, which are your continuing obligations after separation. So for at least 1 year, you can't hire any of our employees to go work on some competitive type product or what have you. The term of that is also negotiable. Now, especially with things like non-competes, you get into more state laws and like what is a conscionable amount of time and what isn't. That's not in this particular contract, but that's the type of thing that you're going to want to be thinking about if you're advising an employer and employee about this type of a clause. And that time period, again, there's case law. Sometimes there's statutes about how much time is allowed and how much isn't. So know your state law and know your case law. But here, this 1 year time period that's in this contract, that you could, if you're the employee, you can negotiate that to be shorter. You could have a carve out, except for, Jane Smith, because I need to take her with me. She's the best, everything is always negotiable is my point. Well, not everything, but generally speaking, things are negotiable, even if this is what you're at first presented with.
Yeah, and it looks like an infinite obligation to protect confidential and proprietary information of the company. Is that normal that you can never talk about the company into the future?
That is pretty normal. And again, every state is going to have maybe different rules around this or different case law, but generally speaking, that's enforceable. And especially with like a giant payout like this, that's right. Probably enough consideration that's an acceptable term, is to keep everything confidential forever. I mean, there may be trade secrets, there may be all sorts of confidential information. So as far as like an enforceability thing, every situation is different and context matters, but in the context of like just how much of a payout this is going to be, this is probably for a much higher up executive, type level, or if not like a C-suite executive, very, very upper management type of separation agreement. I think that that's reasonable. And again, it's sort of company specific too.
Speaking of enforceability, Section 9 talks about enforcement, and there's a nitpick that you've got in there. What do you think about Section 9?
Yes. I am. If the audience caught from the second tip that I had about that shouldn't be there. Yes, I'm a little nitpicky here. So in 9, it talks about uh, stopping payments in the event of a breach, right, of a contract, of this agreement. So so the way that this is worded is it's implying that there's more than one payment, which if you actually read the payment clauses of how the payment is being made, it's being made in a one lump sum payment on a very specific date. And so certainly there's there's a way that you could put in this contract, well, if we've started the payment and you've breached the contract, then we can do everything within the law that it allows us to try to halt that payment from continuing to go through. That's being specific to this exact contract. So I understand that language making sense in a lot of other types of separation agreements, maybe where there's multiple payments or you're unsure about the specific date that a payment is being made. But the way that context matters, right? And when you look at the on the whole of this contract, we know it's only one payment on one very specific date, and so at best it's superfluous because yes, it's a little confusing. Like it's just one payment. Is this ever even going to happen if there's a breach? If there's a breach, it's probably going to be long after that payment was made. So does this really need to be in there? Maybe not. But to the extent that it is confusing, I would recommend some type of amendment like the earlier amendment that I mentioned.
Yeah, and it brings us to a big picture, and I know we're talking about sections that aren't there. For example, the ability to rehire this person. When you see these kinds of things where there are gaps, where there are problems that should be solved, or you see language that doesn't quite match up, it leads you to believe that there's probably some copy pasting going on here. And you and I both know that Law Insider is a place that someone can go and find contract language and theoretically just copy paste it. But what we're trying to do with this show is suggest to people, do not do that, right? Like you need to be thoughtful about the way you use these sections. But I might challenge myself there, which is, what's the trade-off, right? If you are the lawyer who's drafting this document, and going in and nitpicking every single clause is going to take X amount of time, getting out a contract that's good enough to get the deal done, or in this case, to get the separation done. How do you balance that risk of, I want this thing to be really adapted to the moment versus, we got to do thousands of these documents. Let's move on. How do you balance that sort of quality control activity?
Well, for your billable hour attorneys out there, of which I'm not, I'm the subscription attorney,
Right.
You're going to want to spend as much time as possible on a contract, right? So read it from top to bottom a few times to make sure everything's
Write
gone.
it backwards. The only way you're going to know if it's good is if you write it backwards. Yeah.
Right. So, but realistically, if you're putting together a contract from scratch, even if it's copying and pasting from different types of documents that are available on Law Insider, it's your job as the attorney to make sure that it all makes sense after it's copied and pasted together. And does that mean reading it from top to bottom, every single word multiple times? No, of course not. But it means being diligent in when you're putting it together in the first place to make note of what's in there. And a lot of lawyers who I know actually have really good memories, but also don't rely on your memory. Take good notes. I'm a big fan of Google Docs, actually, more so than Word, because I could comment and make notes on things that don't actually change the document, like a track changes type format, a little bit easier and more user-friendly. And so I'll do that as I'm going through a document to remind myself of something. So instead of having to scroll down from top to bottom reading the document, I'm scrolling down top to bottom looking at my notes. And so that's something that you're going to want to do when you're copying and pasting, putting things in there together. And it is hard to know like what's being omitted. A lot of that comes from experience or just familiarizing yourself with a lot of the types of different clauses and options that are out there.
Yeah, it reminds me, I was listening to a podcast about what an artist is in a highly tech engaged world. And it was talking about the OpenAI software where you can create images. And there was one about Shrek the Savior, I think, where it like Jesusified Shrek, and it was hilarious. And you see all these images. And so there's this question, when the technology is doing a lot of the paintbrushing, where is the artist? And I think to your point, in this scenario, and maybe in that scenario too, it's in the questions that we ask and the care that we take to make sure that they're answered. That's the craft. And so I hope that if this show does anything for you guys, it makes you realize that if you don't do that, we're going to make fun of you later. So, Mathew, I appreciate you. Thank you for joining us. For people who want to connect with you and learn more about your subscription model and your practice, what's the best way to connect with you?
Well, LinkedIn, DMs are open, and I always recommend and like more people connecting with me on there. And then Lost Subscribed is the podcast, and you can go to lostsubscribe.com and find it on every single podcasting platform that's out there.
Well, we will have a link to the LinkedIn and to the Mathew over at lawinsider.com/resources. And if you want to be a guest on the Contract Teardown Show, just email us. We are at community@lawinsider.com. We will see you all next time. Thanks again, Mathew.
Thank you.
Thanks so much for tuning in to this episode of the Contract Teardown Show from Law Insider. If you're enjoying the show, please feel free to rate, subscribe, and leave a review wherever you listen to your podcasts. That helps others find the show. We really appreciate it. Thanks again for listening, and we'll catch you in the next episode.